Hi, and welcome to What's the T in L&E. I'm Leah.
I'm Emily.
And we are management side employment attorneys with Woods Rogers, Van Deventer Black. Today, we are talking about harassment that is so severe that it rises to the level of legally actionable harassment.
Yeah, so typically harassment, for it to be actionable, has to be severe or pervasive. That's traditional. Now, some states are eliminating that, and you only have to have something happen one time. It doesn't have to be that severe. But Title VII, which is the federal equal employment law, still requires that something be severe or pervasive. So we're talking about severity. Leah, what does it usually take?
Gosh, it takes one moment of really severe stupidity or offensiveness or derogatoriness, if that's a word, right? So potentially calling someone a terrorist in the workplace. There's a case that says that only one time does that need to happen for it to rise to the level of legally actionable harassment. Using the N-word in the workplace, regardless of the race of the person who's using the word, rises to that level of harassment. Potentially exposing yourself in the workplace.
That sounds right.
Yeah.
It should be severe.
And a new case came out that actually kind of expanded this as well.
Yeah, so in this case, a female employee said that a male coworker, who actually was a little bit senior to her, so kind of worse, like someone who supervised her.
Yeah, ooh.
She said that he came at her and open-mouthed kissed her.
Open mouth? What is an open mouth? Who does that?
I'm not sure.
Who starts with an open? Okay, we don't give kissing advice here at Woods Rogers, but let me tell you this. Start with a peck and then advance.
Work your way up.
Work your way up to the French, right?
Yes.
You don't start with that. Yeah.
So the judge said that there was really no precedent for whether or not open mouth kiss, like the one time of that, could be severe enough to constitute harassment. But honestly, it probably could.
Yeah, absolutely. So what do we do, right? So you've got an employee that does something one time that rises to that level. This is where preventative measures come into play. Mm-hmm. You've got to train employees about what harassment is and what type of conduct can constitute harassment.
Yeah, and what the consequences are for them if they engage in it, and remind them that harassment does not begin and end. Doesn't begin and end. Harassment can happen at work, but it can also happen between coworkers, when they're not at work. So if he had done this to her at a bar, not the workplace, with same thing. Probably same result, because that employee relationship is still there no matter if you're not at work.
Yeah, actually we were doing harassment training a couple months ago for a workplace and someone raised their hand in the audience and they said, well, don't we get like one shot, right? Like what if the relationship could work out? So don't we get one try to advance on a coworker and then if she turns it down, then we can stop? No, that's not the legal standard, okay? So make sure you are training your employees, because you don't want to be in hot water and want the company to be in hot water because an employee is ignorant or naive or just does something purely stupid in the workplace.
Absolutely. And take a look at our video on consensual relationships in the workplace and putting love contracts in place. Those are essentially disclaimers to let you know employees are romantically involved, and that usually precedes this type of event, so at least you're aware and kind of can take some, preventative measures if necessary.
Well, thank you so much. We hope you'll join us next time. Start with a peck.